Okay. Hi, everyone, and thank you for joining another Be Informed session. My name is Carl Buhariwal, and I'm the founder of Be Informed. We help you make good decisions through our seminars that run online. Today's session, will be looking at child matters in the space of family law. And we have two lawyers, Arthur Athan and Deborah Akers, who will be presenting seminars on child support and child inclusive mediation. But before I progress, I'd like to acknowledge the traditional owners on the lands on which we meet today and pay my respects to their elders, past and present. A quick, just little reminder about the disclaimer. So we are based in Australia, and the laws that will be discussed today are Australian law. The intention of this session is not to provide legal advice. It's purely general information only. And if you do wish to receive any advice specific to your circumstances, please do reach out to a legal professional, which could include Arthur or Deb. In terms of the currency of information, it's all based on information relevant to the Australian community, and the date on which this information has been prepared is listed on the start of each section of the slides. So they're all pretty much relevant to and current as of the last 2 months. In terms of housekeeping matters, we'll be commencing with the presentations first by each of our presenters. Arthur will speak first on child support, followed by Deb on child inclusive mediation, and then following that we'll have a session with Q&A. That session gives you the opportunity to ask questions, and then the presenters can provide their responses. To ask questions, please do use the chat function, and that way I can then relay those questions to the presenters for their comment. I've also received some questions in advance via email, so we'll be also sharing those with our presenters too for their feedback. As a reminder, this session is being recorded, so if you are unable to attend the full length of the session, please do view the recording on our YouTube channel. And following the session, the presenters have kindly prepared a one-page handout, which of course I'll be sending through to you through to your registered email address, so you can have that on hand and share that with your family and friends. So on that note, and if Arthur's ready to go, we can progress to the first seminar, which is the overview of child support in Australia. So over to you, Arthur.
Thanks, Carl. Yeah, thanks again for the invitation to come and present again. It's a privilege, and I share a lot of the same ideals, I guess you'd like to say, with Be Informed. It's important for people to know the information about any subject in life before they make a decision in that area. And it's no different when it comes to family law, child support, separation, or even other areas, tax, whole property, any area that affects you in life. So information is really important, and that's one of my goals in life and in practice. It's to be able to provide information to people so they can make really good decisions for themselves for their future. So thanks again. It's great to be here presenting again. As Carl introduced, my name is Arthur. I'm a senior associate lawyer at Maeve, O'Brien and Associates. We're a boutique family law firm in Balwyn North. I practice primarily in family law. I also practice in wills and estates. However, my expertise lies in family law. Today, I'm presenting on the topic of child support. It's a very interesting area that is related to the area of family law and very strongly related. However, it's governed by a separate piece of legislation. So we have the Family Law Act 1975 that governs family law matters. However, in child support, we have the Child Support Assessment Act 1989. They're both federal pieces of legislation. So the law for family law and for child support is the same across Australia, with the exceptions of some differences, some substantial differences in Western Australia, which if you are in Western Australia, I would suggest having a good detailed chat with a Western Australian family lawyer. However, for the rest of the states, all of the information that I'm about to give is very much applicable. Now, just to backtrack a little bit, why child support? Why is child support relevant? How might you find yourself in a situation where you might need to think about child support and consider what it means for you? Well, I'll give you just a quick example. If you are considering separation or you have separated, whether it's a de facto relationship, whether it's a married relationship, if you have children from that relationship, you may wish to consider child support. Child support refers to a legal obligation for parents to financially provide for their children after separation, regardless of the level of involvement they have in their child's life. So important key words there. It's a financial obligation. It's a legal obligation. Now, again, backtracking, what is separation? What counts as separation? I actually covered this in a previous Be Informed presentation, but just to recap, separation occurs where there is a communication. It could be written, could be verbal, could be a certain course of conduct or behavior that shows a relationship has ended. So it might be as simple as a marriage and there's been a quick text message or a chain of text messages whereby it can be presumed that a relationship has ended, or it might be as simple as moving out of a house. That is a course of conduct that shows that there has been a separation and there is a separation date. So child support becomes an issue where there are children and where there is a relationship that has ended in separation. Now, as I foreshadowed before, child support is a completely separate area from other family law matters, such as financial matters and parenting or custody matters. However, child support arrangements are often negotiated and discussed at the same time as financial and parenting matters. Okay, so thanks, Carl, for changing to slide 1. Appreciate that. Of just recapping of what I've just said about child support being a legal obligation, about children after separation, and it's to do with the financial support of children. Moving on to the second slide. Thanks, Carl. So the slide's called Child Support Assessments. I've already talked about the Act, the piece of legislation that overrides, that rules this area of child support. It's a legal area, and there's definitely set law about child support. Now, I should make it clear from the beginning, before going to point B on that slide, that child support is an area that parents can come to agreements on. Okay, so parents very often come to agreements about the amount of financial support they pay to each other, or one parent pays to one parent, and sometimes that is done informally, sometimes that's done formally. I'll talk to you, all of you, about the methods how we can formalize child support arrangements later in this presentation, but I just want to say at the outset that parents often come to agreements about child support, and that is a good thing. Now, you might say to me, how do I know what's a reasonable and what is a legal assessment of how much child support I should be paying my ex-partner or my ex-partner should be paying me? Now, just referring to point B on this slide, parents are entitled to apply to Services Australia for a child support assessment. This is very important. Now, Services Australia is a government body. If you're not already familiar with it, it manages many programs such as Centrelink. Centrelink is covered under Services Australia. It's a federal body, and child support is managed through Services Australia. So any queries about child support assessments is to be directed to Services Australia. Now, what is a child support assessment? A child support assessment is basically an assessment that comes in the form of a short letter or a short report that takes into account each parent's incomes, that's the first factor, as well as the second factor, their respective care percentages of their child or children. Those are two very important factors that Services Australia takes into account. And once they've got those information, they've received that information from both parents, they calculate an amount of child support that needs to be paid, taking into account those circumstances. Now, on to point C, it's important to remember a child support assessment shows the minimum legal amount that a parent needs to pay to another parent for the financial support of their child or children. This is a legal minimum, if that makes sense. People ask me if they can pay less than that, and if it's agreed between parents, of course they can pay less. However, if there's no agreement, then parents who have separated need to abide by a child support assessment and pay child support as assessed. Now, moving on to point D on this slide, it says, how can child support payments be made? Well, payments can be made directly to Services Australia, and that will be arranged through a phone call, through details in the child support assessment that you have been given. So once payments are made to Services Australia, they can and will distribute payments to the other parent. Alternatively, parents can elect to make payments directly to the other parent as long as this is agreed. And this might be to a nominated bank account, for example. Now, in my experience, oftentimes it depends on the dynamics of parents after they're separated. If the dynamics are quite amicable and there's still a level of some trust between parties, sometimes parents can agree to make payments directly to the other parent. However, in my experience, I have seen that once and if trust breaks down, this may become an issue, especially if a parent stops paying child support, or pays the wrong amount, or pays a little bit less than what they're supposed to, and the other parent is trying to enforce and recover the amount that they should have paid. And sometimes this can be an issue for Services Australia. So as a general matter, it's in my experience, it may be a better thing for parents to make payments to Services Australia. However, the downside of that, I should just add, is that sometimes the payments can take a while to be paid and distributed after that. So there's downsides and there's pros and cons to each method, and this is probably a discussion that you should have with a lawyer with your unique relationship circumstances, and to obtain advice accordingly. Now, moving on to the final point in this slide. What if I do not pay child support payments? Obviously, I've put this, please seek advice. You should seek advice, whether you are the one who is refusing to pay the child support payments, or you're the one who is not being paid the correct amount, or not being paid child support payments in accordance with a child support assessment. Now, if child support payments are not being paid, this may result, obviously, in a child support debt or child support arrears being accrued. So child support, through Services Australia, they have legal powers to recover overdue child support in a variety of ways. This is usually initiated by a parent to whom child support payments are usually due, and once that parent wishes to enforce the assessment and recover the arrears in child support, or recover the debt owed to them. So again, this is an area that you should seek advice on if this is happening to you, or if you think this might happen to you in the future. Thanks, Carl. Can we move to the next slide? Thank you. So as I foreshadowed earlier in this presentation, instead of going through an assessment, or even if there is an assessment in place, parents can reach agreements about child support arrangements. Now, as I said there in point A, parents can reach any agreements about child support arrangements. Informal arrangements about child support arrangements are not legally enforceable or binding. That's important to note. Now, parents may agree to refrain from applying to Services Australia for a child support assessment at all. and they can agree to their own child support arrangements. Alternatively, they can apply to Services Australia for a child support assessment and use the assessment as a guide for them as they negotiate and reach agreements about child support arrangements. Either is fine. Obviously, if you'd like to have something concrete to go by, a child support assessment is great to have. If you wanted to have an idea about what child support you might be up for in terms of what you might have to pay or what you might be owed, Services Australia has very useful tools on their website called online estimators. And I'm just looking at it right now on a separate screen, which you might want to just Google for yourself, Services Australia online estimators for child support. And there's basically a calculator where you can input your personal circumstances, and Services Australia can basically provide an estimate of what you might be liable to pay or what might be owed to you. That is a very useful tool that I often recommend my clients to use just at the outset in working out the beginnings of child support and what obligations they might have. Thanks, Carl. Can we move to the next slide? So we've covered informal child support arrangements and we've covered child support assessments. Now, we've talked about how parents might reach agreements. Parents might reach agreements, and informal agreements are not, as I've said before, they're not binding or enforceable. What if you would like your agreement to be made binding and enforceable, or at least written down in a way that shows the intentions of both you and your ex-partner? This is a slide for you, limited and binding child support agreements. Both of these documents, a limited child support agreement and a binding child support agreement, they are written documents with a few differences, and I'll lead you through those right now. So a limited child support agreement is a formal agreement between parents that does not require independent legal advice. However, a child support assessment is required first, and often in that agreement, it's often stated that a child support assessment is often waived. And what that means is it's put aside in favour for the agreement that is on foot between the parents. Important to note that limited child support agreements expire 3 years after being signed. You don't necessarily, as I've said there, you don't need independent legal advice. However, it's always advisable to obtain legal advice about child support in general, but especially when you're entering into any type of agreement. Now, in contrast, a binding child support agreement is a formal agreement between parents that does require independent legal advice. An assessment is required first, so a child support assessment is required. Binding child support agreements are often registered with the Federal Circuit and Family Court of Australia, as well as Services Australia, the child support agency as well, for the purposes of a record of the agreement being reached, and for the purposes of, if there is a breach, it can be enforced if necessary. Now, binding child support agreements are, in my experience, they're relatively common, especially when negotiating financial settlements or property settlements in family law. Just recently, I had a mediation where a binding child support agreement was the tipping point, or if you like, or the sweetener on the cake to get an agreement through. So it can be a very useful, it can be very useful in negotiations in family law financial settlements. And the reason why it's so useful is because both parents often want to prioritize the financial support of their children. And if that is on the minds of both parties when it comes to negotiating a financial settlement, that is often a very good thing. And both parents can easily agree on the fact that they want their children to be financially supported and have the financial support to go to school, the school that they agree on, engage in extracurricular activities, etc., etc. Now, I should mention at this point that there are two different types. In the Act, there are two different types of child support payments. There are periodic payments. Periodic just means regular payments. And there are non-periodic payments. Non-periodic meaning non-regular payments. When we talk about a child support assessment is always for periodic payments. It's always for regular payments. Could be weekly, fortnightly, monthly, etc. However, non-periodic payments it's not covered by a child support assessment. These are usually covered if there is an agreement on them in these type of agreements in this slide, so limited and binding child support agreements. Now, if you want examples of what type of non-periodic expenses or child support expenses that parents might want to agree to, these might include school fees at an agreed school, school books, stationery, school uniforms, agreed extracurricular activities, agreed optional intrastate, interstate, international school excursions, monthly mobile phone bills, private health insurance, or the gap in all medical, dental, optical, orthodontic health expenses. So those are just a few examples, but I mean the list is pretty much dependent on the parent's circumstances and more specifically, the child's circumstances and the particular needs, the particular financial needs for each child. With regard to a binding child support agreement, and both of these agreements, as I've said before, highly recommend that you obtain legal advice. In fact, it's compulsory for a binding child support agreement. So there is a certificate of independent legal advice that needs to be signed by two lawyers to ensure that both parties have received legal advice for a binding child support agreement to be binding and enforceable. Thanks, Carl. Can we move to the next slide? Thank you. Final slide. So challenging an assessment or an agreement and child support orders. Now, what happens if you don't agree with the child support assessment? What happens if someone is in breach of a limited or a binding child support agreement? Well, there are avenues to pursue, and I'm just going to read off point A. It says parents can request Services Australia to review their child support assessment. So that's the first port of call when there is a child support assessment in place. That request is usually made in writing, so you can put down your reasons and go from there. Obviously, Services Australia will get back to you with their reasons and any amendments if necessary. Now, if there's further issues, if you disagree with the reasons that Services Australia has provided, on to B, parents can request an external review of some child support decisions in the Administrative Appeals Tribunal, the Social Services and Child Support Division. Now, the Administrative Appeals Tribunal is a federal tribunal that obviously they've got a division that deals with these type of issues. Now, I have dealt with a couple of these matters. However, generally, as a general principle, it depends on each circumstance. But the situations that I've seen, it's most times not worth the time and the money to pursue such course of action. However, that's heavily dependent on your unique circumstances. Strongly recommend that you receive some good quality legal advice in regards to your specific circumstances. Moving on to point C, in limited circumstances only, it may be appropriate for a parent to seek interim or final orders in the Federal Circuit and Family Court of Australia regarding child support matters. Now, this is amongst lawyers, we call these type of orders child support departure orders. Now, these are sought in very limited, rare circumstances where the parties don't agree about child support arrangements, and perhaps there's already proceedings on foot, or proceedings are about to be issued for property or parenting matters already. Now, a number of factors are usually considered by the court in regards to such orders, and these include the child's needs, each parent's financial circumstances, any prior agreements between the parents, or status quo arrangements that have been on foot for a while, and any hardship caused to the child or either parent if a departure order is made or refused. Now, the purpose of such orders is firstly to set aside, to depart from a child support assessment, and to provide a regime, provide orders for the alternative financial support matters for children. Again, they're these type of orders are very rare. Oftentimes, the whole matter of child support can be dealt with solely through Services Australia. Very rarely does it proceed to a challenge stage, if you'd like to call it that, through the Administrative Appeals Tribunal, and child departure orders through the Federal Circuit and Family Court of Australia are very, very rare. However, they do happen, obviously, from time to time. I hope that gives you a little bit of a taste into the world of child support. If you're going through a period of time where this area applies to you, I've said it numerous times throughout this presentation, please see a lawyer. Please get some good quality legal advice about your unique circumstance, and you'll be ably assisted with that advice to make good decisions about where you should go and what your next steps should be. But hopefully from this presentation, you now know about Services Australia, you know about how to seek a child support assessment. You don't need a lawyer to do that. You can apply for a child support assessment yourself, and Services Australia can enforce the start of those payments. So if you're in a situation where you need child support and you're entitled to child support, you can make that application, and those child support payments should commence upon the assessment coming into effect. I hope that gives you a little bit of a taste, and feel free to contact me if you have any more queries. I look forward to the Q&A after Deb has presented. Thanks, Carl.
Thanks, Arthur, for that presentation.
Thank you.
There are his details on screen. So yes, I think that was quite a lot of information that you've shared around child support agreements and how they are assessed and how they are sort of put together and then enforced, and what happens if you don't pay them and the like. So I think very, very relevant information there, especially when it represents a financial obligation and ultimately support the well-being and sort of growth of the child. So thank you again, Arthur, for sharing the information. We'll now, just before we proceed, I'll just quickly remind you that if you want to sort of submit a question, please send it through the chat function, and I will then relay those questions directly to the presenters. The next seminar will be presented by Deborah Akers. She is a lawyer at Stellan Family Law and is very much across child inclusive mediation. So Deborah, if you're ready, please go ahead in sharing your presentation.
Thanks, Carl. Sorry, just having a bit of a technical issue there. Thanks very much for the invitation to present tonight. As Carl has said, I'm a family lawyer. I run a sole practice in Melbourne, but of course these days everything's done by Zoom. I was very interested with Arthur talking about Western Australia. I used to have a fairly good sized practice with my business partner in the Pilbara. So I've done a lot of work in Western Australia, and I do some mediations in Western Australia. I am also a family dispute resolution practitioner, and so that means I'm registered with the Attorney General's Department and commonly known to people in this space as a family mediator. I'm also an NMAS, or a nationally accredited mediator for non-family matters, and I do some of those as well. Before I start my presentation, I just want to give you my background and why I have a special interest in children's matters. Before becoming a lawyer, some 12 years or so ago, I was a maternal and child health nurse and an academic teaching in the area of child's development, and in working a lot with children who were going through family separations, child protection matters, family violence, all of those sorts of issues. So I have a really good grasp, or I believe I do, on those issues for the families and for the children in particular. I also ran a private business supporting families who were going through difficulties. And then I became a lawyer and used those skills to inform my legal work. So I have a particular interest in working with children and with families who are experiencing difficulties in their parenting matters. I also do property, just by the by, but I do have a particular interest in children. Carl, if I could have the first slide, please. Thanks. So what is child inclusive mediation? And I don't know the audience, but I'm going to just assume that you've come here to learn about child inclusive side of mediation. The FDRP, or the Family Dispute Resolution practitioner, is not necessarily going to be someone who does child inclusive mediation. And in fact, my view is that best practice is that the child consultant who assists your mediator is best to be someone who is not the same person. You're best to have two separate individuals for those. The child inclusive mediation is an addition, and some would say a very important addition to family dispute resolution as a whole. It's designed to share the thoughts and the reflections of every child going through the situation, either as a sibling group or on their own, their experience of their parent separation, but mindful of their stage of development. So you might want to, if you are the child consultant, interview groups of children in a sibling group, or you might want to interview them individually. It's really only appropriate for children who can express their feelings, and I should have put the word verbally in there, someone who can express their feelings verbally, usually from about the age of 5. If they're having trouble with words, there are a range of tools that child consultants use that involve things, and I'm going to hold them up. I'm hoping you can see little Lego blocks that have feelings on them, or I can play basketball with them and they can give me their feelings on the basketball. But really, you need to talk to children who can express things verbally to you. The work of the child inclusive mediator is also, as mediation and family dispute resolution is, it is confidential. It is confidential and it is inadmissible in court in just the same way as FDR work generally is. And those of you who may be listening and thinking, I've been asked to go to mediation, or someone has suggested it, if you have a separation and a parenting matter along with that separation, then one of the pre-action procedures that you must undertake, or at least attempt, and I'm not going to go into all of that now, is family dispute resolution. And this child inclusive process runs along beside the family dispute resolution or the mediation. Could I have the next slide, please, Carl? So I've sort of talked about what it is, and I'll talk about the process in a minute, but what is it not? Some parents worry that approaching a child consultant to assist with the family dispute resolution is going to open the floodgate, and that they're going to be expected to give the children what they want. I make it very clear to the children that it is not they can give me their wish list, but it is the parents who are in control of the outcome of the mediation and of the parenting arrangements. It is not about the child dictating what they want, although what they want can be very important to the parents in deciding and taking into account the children's feelings and what their experience of the separation. It is also not me acting as detective who goes in and finds out what separated parents want to know their children are thinking, and me report back verbatim what the children have said. What the consultant is to do is to get the feelings, interview the child, make an assessment. I always do a bit of a report afterwards just for me to check things off when I do speak with the parents. And then the consultant has to check in with the child. Do you want me to tell your parents what you've told me? Is there something, and I probably asked last week's girl about 6 times, I think, in my interview, are you sure there is nothing that you want me not to say to your parents? Or is there something you're worried about? Children can be frightened that if they say things that they're going to go back, and that either parent about whom they might be critical, or the arrangements, and one parent's resisting changing and the children want change, they can be fearful that there's going to be repercussions. But I assure them that I make it very clear to parents that it is not about punishment, repercussions. And I also make it very clear to the children that I'm only going to tell their parents what they give me permission to tell them. And that, as I said, that doesn't mean they get their wish list. Girl last week gave me, exactly what she wanted. Is there anything I can't tell your parents? No, I want you to tell them all of this. And that's fine too. Can I have the next slide, please, Carl? So who is a child consultant? This is a slight diversion before we talk about the process. There are actually no mandatory qualifications for child consultants, although there are courses that you can do, and I've done some of them on top of my master's and my other things that I've got. In my view, and this is a personal view, ideally they will be a family dispute resolution practitioner themselves, so they will understand the mediation, they'll understand the process, they'll understand the confidentiality and all of the things that underpin that process. They will have further qualifications in child development, social sciences and other areas such as counselling. A lot of social workers who work in this space become child consultants. You need to have a rapport with children and some qualifications in that area. And again, this is my personal view. You need to have an understanding of the developmental issues such as autism spectrum disorder and other perhaps neurological or physical or other differences in children. And of course, you must have a working with children check, which actually goes with the FDRP role. You have to have one anyway. But they're to my way of thinking, and I'm happy to be challenged on this, but I think that's what a child consultant should have as a minimum. Could we have the next slide, please, Carl? So how does it work? Well, basically, the process is the same, but sometimes the timings are different, and that might be because of the professionals involved, or it might be because of the parents. So generally, the parents have to consent to the process. So if I'm approached by an FDRP or a lawyer or parents, sometimes parents self-refer, I will speak to both parents to get their consent to enter into this process. I will then, as you do with your mediator or FDRP, I will interview them separately. I will do a pre-mediation intake. And in that interview, it's not as in-depth perhaps as a pre-mediation intake, but I need to get to know where they're at with the parenting arrangements and what they are hoping to get out of this. So I do effectively a pre-mediation interview with both the parents. I then speak with the child or the children. Now, this can be in a sibling group, as I said, or individually, or siblings and then individually. It doesn't really matter. And it can depend on the situation and the ages of the children. COVID really killed it a bit. Not great to try and do this work, I don't think personally, on Zoom, but teenagers, they often engage on Zoom, and that's not a problem either. I see the children at perhaps one of the lawyers has a room, one of the parties' lawyers, if they've got lawyers engaged, has a room where they'll let me have an interview room with the children. I make it very clear that whoever is dropping the child to me, I'm not engaging in conversations with them, because I'm very, very specific that I am not going to have any appearance of bias between the parties. So everybody gets told the same thing at the same time in my world. Once I've spoken with the children, and that might be an hour, less than that sometimes, more than that, depends, I then get my thoughts together and I report back to the parents and to the mediator who is going to conduct the mediation. The discussion will be around developmental issues, and again, only what the children have agreed should be shared. Sometimes children don't have the words for it, and again, I'm going to hold something up that may not be seen, but I have a series of bear cards that I used to use in my former counselling role. And sometimes, as this girl did last week, and I'm not showing you her card, but sometimes the kids say, yep, show my parents this, because this is how I'm feeling. Now, just as an aside, can you see that little card? That bear there is not very happy. Then there's cards that say, I really just want to run away from this whole thing. I'm sick of my parents fighting. And that's the language that the children are able to express. And sometimes a card is really good because it encapsulates their feeling at the time. And I ask permission. Can I show your parents this? Because I reckon this is really how it is. Is this what you're telling me? So once I've had the session with the parents and the FDRP, and it's a joint session, I will not speak to parents individually. I am asked if I can speak with parents individually to report back, but I don't. I speak to them both. The FDRP that is going to conduct the mediation is also present. And then after that, the mediation occurs. My preference in practice is that I do all of my bit up to meeting with the parents and the FDRP, and then they have a few days to think about it. Some FDRP practitioners and some parents, for want of time or just processes, they will hear what I have to say and then they'll want to go straight into mediation. My personal view is that they need a day or two to kind of digest this, because parents come with their own agendas. And I say to the kids all the time, I know what your parents are going to, they're going to tell me what they think I want to hear. What I want you to tell me, they're going to tell me their side. What I want you to tell me is how it is for you. It's a bit like, if you are familiar with the court system, it's a bit like having an independent children's lawyer appointed. So I've lost the slides, but I think that might actually almost be the last one. No, Carl, there is another slide there. If you can get it up, I seem to have lost them. No? I'll go ahead anyway. I guess what I wanted to say was, is this right for your family? Is the child inclusive mediation right for your family? And you need to discuss that with your mediator, who may have consultants they already use in their process. All of us mediators and lawyers have got referral people on our lists. And then seek out child consultants, interview them, talk to them, see if you've got a rapport with them, see if you like their qualifications, think, will they relate to my child? And then if you want to engage in the process, then have a chat with us and book us up. I wanted to say one thing about costs, and that is that as a family lawyer, I'm very mindful of people's costs, and as a mediator. Yes, it does add to the cost of your mediation, but in the long term, you are allowing the child's voice into the mediation space and hopefully bringing that into any parenting arrangements, which for the sake of harmony and moving forward should be of much benefit to your family. So I can be contacted. My details will be up on the screen. I just wanted to thank everyone for attending and thank Carl again for the invitation to present. And that's about me, I think. Thank you.